गुड मॉर्निंग माय डियर फ्रेंड्स, प्यारे दोस्तों। आज फिर एक बार आपके सामने दिस इवनिंग आई एम गोइंग टू टॉक टू यू हाउ टू हैंडल a show cause notice after it is issued. I will be covering from the time a show cause notice is issued and up to the time when an order is passed under section 73(9) or under section 74(9) of the GST Acts. So this is specific to the show cause notice under section 73 or 79, 74. There are different ways people handle show cause notice. There are people who do not reply to the show cause notice at all. At times many of the assessees reply to the show cause notice and participate in the adjudication process and wait for the order to be passed by the assessing officer, by the proper officer under subsection 9 of section 74 or section 73 respectively. There are some assessees who rush to the High Court to quash the show cause notice under the writ jurisdiction of the High Court to obtain a writ of certiorari. Yet there are some cases where the assessees reply to the show cause notice and during the stage of adjudication they approach the High Court for ensuring natural justice. So which is correct, which is better, which is wrong, there is nothing of that type. चारों options है. There is no straight jacket formula or fit all solution as to how to handle the show cause notice. It depends upon the circumstances, the recitation of the show cause notice. Even we can go to High Court even after the order has been passed under 74(9) or 73(9) of the GST Acts. So various options are there. When we can, I will restrict myself to the option of approaching the High Court under the writ jurisdiction. When can we go? When cannot we go? That is the major topic I will be covering. The writ jurisdiction is available even at the face of alternate remedy. Alternate remedy होते हुए भी writ jurisdiction के लिए High Court intervene करता है on specific grounds. Natural justice, denial of natural justice, lack of jurisdiction. The apparent error of law, patent error of law, procedural violations, and no evidence. No evidence means no evidence, not inadequate evidence. In these cases, High Court have time and again frequently has intervened even if there is an alternate remedy. Out of that, the biggest ground, the most frequently used ground is denial of natural justice. I have explained to you earlier, there are three components of the natural justice. The opportunity of being heard before an adverse action is taken. Nobody should judge his own matters. Nobody should sit on judgment on matter he is interested in. And lastly, a right to have a detailed order. All these things are three limbs of natural justice. In this case, during the process of adjudication and at the time of issuance of the show cause notice, the opportunity of being heard is the issue that comes to the fore. So natural justice is the biggest law in almost all constitutional courts within our country and in all modern countries. This is the basic of one of the basic right of human right. The challenge is to understand now. So courts are willing to entertain petitions for denial of natural justice and other aspects also. But under the natural justice, what are the issues that we can raise, then we should understand. The challenge is to identify when is the natural justice denied. For that, the challenge is to understand what are the components of natural justice. What are the components of opportunity of being heard. There are confusions. Everybody is not equally informed about it. When I say everybody, the assessees, the assessing officers, the accounting professional and the legal professionals. There are a lack of clarity as to what constitutes the opportunity of being heard. There are a lot of confusion, a lot of misunderstanding that opportunity of being heard arises during the adjudication alone, and when a sentence is added in the show cause notice stating that there will be a personal hearing, the assessee can avail a personal hearing, then we think that personal hearing is granted and natural justice is fulfilled. So we must understand what is personal hearing first. Personal hearing is not personal audience. Many think that once there is an audience, we go and meet. हम जाके assessing officer को मिलता है और वो हमारा बात सुनता है, तो personal hearing का बात fulfill हो गया. वो नहीं है personal hearing. Personal hearing has got different components. In personal hearing, there is a right for us to rebut the evidence produced by the revenue, by the department. There is a right for us to rebut the documents that has been produced. There is a right for us to represent, to right for us to produce our witnesses and evidence through those witnesses. And there is an opportunity for us to bring our own documents also and witnesses also and offer our witnesses for cross-examination. All these things are part and parcel of hearing. तो hearing is different. तो सुनने का बात नहीं है, सुनवाई होने का बात है. It is hearing in legal sense. It is not just listening or just audience or just having a meeting. It consists of all these things. So if that is the definition of personal hearing, we must also know what is the evidence that we can produce. What are the witnesses, for what purpose we can bring the witnesses. What are the documents we must produce, that we must know. Then only I can rebut it. So, at the time of issuance of the show cause notice itself, we must be told the allegations clearly, specifically. Just saying that you have not paid IGST fully, you have short paid and you have to pay 10 lakh rupees more. That is not a show cause notice, that is not a clear-cut allegation. The legal provisions on which I am required to pay the tax at a particular rate, by which notification that rate has been fixed, and the violation that I have done, the quantification of that, how much interstate supply has been made, in which all months. Month is important. Month is important क्योंकि जब एक महीने का जो ट्रांसैक्शन के बाद में, जो सप्लाईज का बाद में, सेल्स का बाद में, अगले महीने हम उसको we are going to pay the tax. So if we have not paid the tax, the interest will be calculated from that month onwards. So there is a section 15 which says about the type of supply, and there is a section 9 that is detailing about dealing about the charging section. So as per this charging section, what supply I have made to which state, if it is interstate, and at what rate I should have paid the tax, and what actually I paid, what is the shortage, this must be brought in. So this provision, the quantifications, which are the sections or the provisions of law that I have violated, and what is the provision of law that gives power to the assessing officer to take action, to proceed against me and to take the proposed action. These things constitute the ground. So grounds should be informed to us. Then only I can rebut the ground. Then only I can, if I am innocent, I can unsettle the ground only when these things are told to me. Then only I have an opportunity of being heard because I have to rebut all these things. Then it has also been told what are the facts that has come to their notice. Because GST Act says, the section 74 and section 73 says, where it appears to the proper officer. So to appear to him, there has to be certain documents, certain facts that has come to his notice. So that facts which has come to his notice, and through which evidence and through which document, that has to be shared, then only I can say what document you are relying upon is not correct. I have got another document to prove that I am correct, or it could be only an error. This is what is correct. I have to prove it. So the evidence that they are relying upon, the document that they are relying upon has to be shared with me, and the proposed action also. So when all these things are met, then reasonably a show cause notice is complete. But in case the show cause notice is invoking section 74, then there are added requirements. 74 has got higher penalty and higher period of limitation, but it has got certain conditions. The jurisdiction can be acquired only when there is a misstatement, willful misstatement of facts, suppression of facts, fraud to evade tax. So either has to be willful misstatement or a suppression of facts or a fraud to evade tax. So one of them has to be averred and ascertained, or they have to state these are the facts, these are the allegations. So for that, the facts out of which they have come to this conclusion, that has to be set, that is called the jurisdictional facts. The jurisdictional facts also has to be shared, then only I can rebut it. If I wanted to repel the jurisdiction of the proper officer to issue a notice under section 74, so that if the limitation is over after 3 years, then I can say you have got, you cannot issue this show cause notice under section 74 because it doesn't qualify to be, the section 74 is not applicable in this case. If I have to say so, the jurisdictional facts has to be told. So the jurisdictional facts also has to be informed in case they are issuing section 74. Otherwise, all other things what that constitutes short payment, non-payment, wrongful availment of input tax credit or wrong refund, all those things are also to be alleged, and they have to support it with whatever document they are relying, so that I can refund it, I can repel it. So these are the requirements of a proper show cause notice to be issued. So in that case we can say natural justice is granted to us. And if you have been given a personal hearing or a direct hearing or an oral hearing, then we, as I said earlier, we can produce our evidence, we can rebut the evidence. We are very sure what evidence is to be rebutted, what evidence has to be brought in. What document is incorrectly brought in and what is the correct document which will prove my point if I am innocent. And I can make my representation. So these are the essential aspects of natural justice, essential aspects of opportunity of being heard. So as I said earlier, जैसे मैं पहले बोला था, challenge is to identify the violations of natural justice. Challenge is to understand what are the components of opportunity of being heard. Where it is violated, we should be able to tell, then we can go to High Court. Similar things will arise even after the order has been passed. That we'll cover it in another session. So today I have spoken about natural justice, the opportunity of being heard, the meaning of personal hearing and the meaning of hearing itself, and the denial of natural justice, denial of opportunity of being heard at the time of issuance of the show cause notice itself. So as I said earlier, जैसे मैं पहले बताया था, जो प्राकृतिक न्याय का जो वायलेशन होता है, ये इश्यू करने के टाइम पे भी होता है और एडजुडिकेशन प्रोसेस के दौरान भी होता है. जब एक्ट कहते हैं कि इसके अंदर when it appears, जब प्रॉपर ऑफिसर को दिखाई देता है, तो इसको अगर दिखाई देता है तो मुझे भी दिखा सकता है। भाई साहब, आपके खिलाफ में हमारा ये एलिगेशन है, हमारे पास ये डॉक्यूमेंट्स है, ये फैक्ट्स हमको नजर आया, ये एविडेंस हमारे पास है, ये डॉक्यूमेंट्स हमारे पास है, और आपने सप्रेस किया है, गलत इंफॉर्मेशन जानबूझ के दिया है, अपने फ्रॉड किया है, तो इसके लिए मेरे पास में ये फैक्ट्स है, ये एविडेंसेस है। इतना बोलने पर मैं उसको रिबट कर सकता हूं। सो दिस इज these are some of the aspects, or these are the most important aspects of ensuring or enforcing natural justice, to identify the violation of natural justice, to identify the violation, to identify the components of natural justice. When we say, अगर आपको खाना अच्छा मिला, ये खाना अच्छा था, आपको पता है अच्छा है कि खराब है, तो the food has to be good, we will say it has to be warm, fresh or hot, it should have rice, it should have chapati, it should have some vegetables, something for protein, some pickle, some sweet, all these things are there, and condiments are there, proper mix is there, salt is proper, we know the food is good. So if only rice is there, there is no sambar, there is no dal, then we will say food is not good, or food is given, chapati is given, after 1 hour if the rice is given, or after 1 hour sambar is given, we know food is not good, not properly served. So we know it. What are the components of the food? We know it. So we can say if it is good or bad. Similarly, unless we know what are the components and ingredients of natural justice, ingredients of opportunity of being heard, we will not be able to counter it. So we will not know where to go. So either we will not reply, or we will reply and will participate till the time the order comes. And then also we will not know when it was violated, where it was violated. So many of us are suffering, not because of our mistake, any mistake that we have done. We do not know how to counter the allegations that is in the show cause notice. The details are not given. The allegations are not clear. So I will like to wind up now about this topic of violation of opportunity of being heard, the denial of opportunity of being heard. जो सुनवाई नहीं होता है ठीक से, जो पूरा सुनवाई के लिए मुझे मौका ही नहीं मिलता है, मेरा बात प्रेजेंट करने के लिए मुझे पूरा मौका नहीं देता है, इसके बारे में मैंने कवर किया. Next, I will try to explain in next session how the natural justice is denied by not having a detailed speaking order in the order that is passed by the assessing officer under section 74(9) or under 73(9). Thank you for today. See you once again.